In reference to written and unwritten constitution, most of the people remain either confident or maybe in confusion that the written constitution means the constitution, which is codified and written and available in the form of book, whereas unwritten constitution is such legal provision which are not written, rather practiced traditionally. Hello everyone. In this video, I will explain the meaning of written constitution and unwritten constitution, and then we'll discuss the major differences between them. So be with me. Let's first understand the meaning of written constitution. Written constitution is the collection of provisions or rules which are profoundly organized, systematic, and documented, normally in one book as of India, the United States, and in a series of documents as of France, Australia, etc. The constitutional provisions, which are duly enacted, are the fundamental rules that define the features and functions of different organs of the government and other subsidiary bodies of government. In all countries having the governance on the concept of rule of law, have the written constitution. However, there are a few exceptions. Now, let's discuss the merits of the written constitution. The written constitution is well defined and has certain sets of provision. The written constitution protects the fundamental rights of the individuals. The written constitution is normally promulgated on a specific date. The written constitution is normally rigid, as the amendment process is lengthy and complex, as well as certain provisions cannot be amended. Now, come to unwritten constitution. Unwritten constitution is fundamentally the provisions or set of rules that evolved over period in time through judicial and governance practices. Likewise, there is as such no defined document where one can get the whole constitutional provisions, rather there are various documents that collectively define the constitutional provisions. The Constitution of Britain is the best example of unwritten constitution. At this point in time, I would like to clear one point, i.e., I believe, now, you don't have the confusion that unwritten means something not written. Rather, Britain's constitution is also written, but it is not well defined, organized, systematized, and documented at one place. It means, in Britain, there is as such no one document that can be called as constitution. Rather, the constitutional provisions are available in sporadic form, which means available in various different documents. Such constitutional provisions largely consists of customs, conventions, traditions, and of course some written laws, which are written on different dates, which normally evolved over period in time. For example, as I mentioned above that the Britain's constitution is unwritten, so the foundation of Britain's constitution goes back to 13th century, when the first Charter of British Freedom, popularly known as Magna Carta, was issued. Since the Britain's constitution started its formation, especially through conventions and usages. Now, let's discuss the merits of the unwritten constitution. The unwritten constitution is adaptable, as it can be changed easily. It is progressive in nature, as there is no limitation of any pre-documented or written constitutional provision. The unwritten constitution is flexible, as people can bring changes without undertaking revolutions. The unwritten constitution is a continuous process of its development, etc. Now, let's discuss the major difference between written constitution and unwritten constitution. Written constitution is properly defined, organized, and duly enacted legal provisions, whereas unwritten constitution comprises of legal provisions of the government that have never been enacted in the form of laws. Written constitution is the result of deliberate, conscious and collective efforts of people, whereas unwritten constitution is unsystematic, sporadic, and essentially not the result of conscious and collective effort of a few lawyers and legislators. Written constitution is drafted and duly enacted on particular date in history, whereas unwritten constitution is developmental process and evolved over period in time and essentially not on specific date. Written constitution is rigid in nature, as it needs proper provisions of Constitution to amend any of its provision. Some provision are not at all amendable, whereas unwritten Constitution is flexible, as its amendment does not require any strict legal provision. In the countries having the written Constitution, the distinction between constitutional law and ordinary law, which is also known as statutory law, is maintained, whereas in the countries having unwritten Constitution, there is as such no distinction maintained between constitutional law and ordinary law. So, this is all about the concept of written Constitution and unwritten Constitution along with the major differences. However, if any one of you have still any confusion, you may ask through the comment box given below. And yes, if you did not subscribe, then please subscribe our channel to watch more such informative videos. Bye bye. See you in next video.